If you are waiting for a green card right now, whether you are on an employment-based visa like an H-1B, or you are a family member sponsored by a U.S. citizen or a permanent resident, then what I am about to share with you in the next few minutes could have a direct impact on your timeline, your filing window, and your planning for the months ahead. My name is Host Name, and this is Immigration News Today. We are here every single day to break down the latest immigration updates so that you can make informed, confident decisions about your future in this country. And today, we are talking about one of the most important monthly documents in all of U.S. immigration, the Visa Bulletin. Specifically, what the February 2026 numbers are telling us, what immigration professionals are watching closely for March, and most critically, why a certain risk that has appeared before in this system is worth paying very close attention to right now. So let us start from the beginning, because I want to make sure everyone watching this, whether you are new to immigration or you have been in this process for years, truly understands what we are dealing with. The Visa Bulletin is a monthly publication released by the U.S. Department of State. Think of it as the official waiting list for green cards. It tells you, based on your visa category and your country of birth, whether or not a green card number is available for you at this particular moment. This matters because even if your immigrant petition, your Form I-140, or your family-based Form I-130 was already approved, you cannot move to the final stage of getting your green card until the Visa Bulletin shows that a number is available for you. The date associated with your category in the Visa Bulletin is called the priority date cutoff. If your personal priority date is earlier than what is listed, you are eligible to move forward. If it is not, you wait. It sounds simple, but the implications are enormous for hundreds of thousands of people. Now, there is something very important I want you to understand about how this system works at a deeper level, because this is where a lot of people get confused. The U.S. Congress sets an annual cap on how many green cards can be issued in the employment-based and family-based categories each year. For employment-based green cards, that annual worldwide limit is at least 140,000. For family-sponsored preference green cards, it is 226,000 for fiscal year 2026. On top of that, there is a per-country cap. No single country can receive more than 7% of the available visas in a given year. 7%. That might not sound significant until you understand what it means for countries like India, China, Mexico, and the Philippines, countries that generate enormous demand for U.S. green cards. When demand from those countries exceeds what 7% of the global cap allows, backlogs build. And for some countries and categories, those backlogs have grown to staggering lengths. For Indian nationals waiting in the EB2 employment-based category, the current priority date cutoff as of February 2026 sits at December 1, 2013. Let that sink in for a moment. People who filed their petitions over 12 years ago are still waiting. That is the structural reality of this system, and it is the backdrop against which we have to read every single Visa Bulletin. So let us talk about what the February 2026 Visa Bulletin actually showed us, because March's numbers will build directly on February's foundation. The U.S. Department of State released the February 2026 Visa Bulletin in early January 2026, and USCIS confirmed that for February, applicants in both family-sponsored and employment-based categories should use the dates for filing chart. This is actually a positive signal worth noting, because it means USCIS is actively encouraging eligible applicants to submit their adjustment of status applications, their Form I-485. Even if the final approval is not yet possible. Filing early means your biometrics get done, your employment authorization can be obtained, and your case moves into the system. That is a real benefit for those who qualify. Now, what did the numbers actually say in February? In the employment-based categories, the EB1 category, which covers priority workers, including people with extraordinary ability, outstanding professors and researchers, and multinational managers and executives, remained current for most countries, meaning anyone in those categories outside of China and India could file without restriction. For China and India, The EB1 final action date held steady at February 1st, 2023. That is actually a notable position for India, because just a few months earlier, in the January 2026 bulletin, EB1 India saw a significant advancement of nearly a full year. That kind of jump is rare, and immigration attorneys noted at the time that it likely reflected lower than expected usage of visa numbers by Indian nationals in that category. The February bulletin held that date steady rather than advancing further, which analysts read as the Department of State stabilizing after that strong jump. In the EB2 category, for professionals with advanced degrees or people of exceptional ability, February showed no movement at all. For India, the final action date remained at July 15, 2013. For China, it stayed at September 1, 2021. For the rest of the world, the final action date held at April 1, 2024. The dates for filing chart for EB2 India remained at December 1, 2013, and for China at January 1, 2022. The stability in EB2 after January's modest gains reflects what immigration analysts describe as a stabilization or recalibration phase. The Department of State is watching how many applications came flooding in after January's advances before committing to further forward movement. The EB3 category, covering skilled workers, professionals with bachelor's degrees, and other workers, told a more encouraging story in February. For most of the world, Mexico and the Philippines, the EB3 final action date moved forward by just over 1 month to June 1, 2023. And on the dates for filing chart, EB3 worldwide advanced by 3 months to October 1, 2023. That is meaningful for applicants in those regions, and immigration professionals are watching whether March continues that momentum or whether we see a slowdown. For China and India in EB3, there was effectively no movement. China's final action date remained at May 1, 2021, and India's stayed at November 15, 2013. There was also a significant and quietly important development affecting the EB4 category, specifically the certain religious workers subcategory. That program, which had been extended through H.R. 5371, signed into law in November 2025, expired on January 30, 2026. As of February, that subcategory is now listed as unavailable across all countries. No final action can be taken on those cases unless and until Congress passes new legislation extending or reinstating the program. If you or someone you know was relying on a religious worker visa or green card in that subcategory, this is something that needs immediate attention from a qualified immigration attorney. The situation remains fluid, and only legislative action can change it. Now let us turn to the family-sponsored categories, because for many of our viewers, spouses, parents, siblings, and adult children of U.S. citizens and permanent residents, this is where your story lives. The family-based categories also saw measured movement in February. For most countries worldwide, family-based categories showed minimal change. However, Mexico saw more notable advancement in February. The F1 category, for unmarried adult sons and daughters of U.S. citizens, advanced by 3.5 months in the final action dates to December of 2006. The F2B category, unmarried sons and daughters of lawful permanent residents, moved forward by 3 months in both final action and filing dates. Mexico-specific movement has been a trend in recent bulletins, which reflects an ongoing effort to reduce some of the historic backlog that has built up for Mexican nationals in family categories. So the picture going into March is this: modest, controlled forward movement in certain categories, stability or stagnation in the most backlogged categories for India and China, and an overall system that is in what multiple immigration law firms have called a measured pace through the middle of fiscal year 2026. And this brings me to the most critical point of today's video: the risk that every single person waiting for a green card needs to understand and take seriously right now. The risk is called retrogression, and I want to be very clear about what that word means. Retrogression is when a priority date cutoff in the Visa Bulletin moves backward, not forward. The date that was current last month is no longer current this month. And if that happens to the category you are in, it can mean that even if you were previously eligible to file or had already filed, the system effectively pauses you. Why does retrogression happen? Because the annual visa number caps are fixed by law, and when demand in a particular category exceeds the supply of available numbers, the Department of State has to pull the date back to prevent overissuance. We have seen this happen in recent history. In August of 2025, the Department of State warned explicitly in the Visa Bulletin that the EB2 category was rapidly approaching its annual limit, and that retrogressions or unavailability could occur in EB2 and EB3 before the fiscal year ended on September 30th. That warning proved accurate. We have also seen dramatic retrogressions in past fiscal years that caught applicants completely off guard. Here is why this matters for you right now in early 2026. We are currently in the middle of fiscal year 2026, specifically month 6 as of March. Immigration professionals and attorneys across the country are sounding a consistent note of caution. The early months of the fiscal year sometimes lull applicants into a sense of security. Dates move forward, filings pick up, and then in spring and summer, as usage of annual visa numbers accelerates toward the limits, the Department of State begins to tighten. One prominent immigration law firm put it this way in their January 2026 analysis: retrogression risk typically rises in the spring and summer, and modest movement now can signal tighter controls ahead, not faster progress. Multiple firms have been advising eligible clients to file their I-485 adjustment of status applications as soon as their priority date is current under either the final action dates or the dates for filing chart, precisely because filing locks in your place in line even if dates later retrogress. So what should you actually do right now? The first thing, and I want you to pause this video and do this if you have not done it already, is to locate your priority date. This is typically found on your approved Form I-140 for employment-based applicants, or on the Notice of Action for your Form I-130 if you are in a family-based category. The date on that notice is your priority date. Once you have it, go to the official USCIS website, uscis.gov, and check the current adjustment of status filing charts, which are based directly on the Department of State Visa Bulletin. That page will tell you whether USCIS has authorized the dates for filing chart or the final action dates chart for the current month, and you can compare your priority date to the cutoff listed for your category and country of birth. Second, if your date is close to the cutoff, meaning within 6 to 12 months of the listed date, now is the time to have a serious conversation with a qualified immigration attorney. A good attorney can help you assess whether you are positioned to file, whether your documents are in order, whether your employer's support is still active if you are in an employment-based category, and whether any strategy like interfiling, moving from one preference category to a potentially more favorable one, could benefit your situation. Interfiling is a complex decision and not right for everyone, but it is exactly the kind of strategic option that only exists if you are actively engaged with your case and not waiting passively. Third, make sure your underlying petition remains valid and your supporting documentation is current. This is something people often overlook. If your I-140 was approved and years have passed, your job circumstances may have changed, your employer may have restructured, or your personal documents like passports and medical records may need updating. None of this should catch you off guard. Do a regular audit of your case file. Know what is in it. Know what has expiration dates. And verify that your attorney of record, if you have one, is still reachable and up to date on your situation. Fourth, for family-based applicants, be aware that joint sponsor financial requirements and affidavit of support documents can also need updates over time. The I-864, which is the affidavit of support submitted by the petitioner, must reflect current income that meets federal poverty guidelines for the household size involved. If your petitioner's financial situation has changed, that is something to address proactively rather than scrambling to correct it at the time of your interview. Now, for those of you watching who are in the diversity visa category, the DV 2026 lottery, I want to give you a brief but important reminder. The Visa Bulletin publishes monthly cutoff numbers for diversity visa applicants as well, and the entitlement for all DV 2026 applicants ends on September 30th, 2026. That deadline is absolute. Diversity visas cannot be issued after that date, and USCIS and the State Department have warned that numbers could be exhausted before September 30th if usage accelerates. If you are a DV 2026 selectee, treating this process as something you can slow walk through the summer is a real mistake. Move as fast as your case preparation responsibly allows, consult with an attorney if needed, and monitor the monthly cutoff numbers closely. Before we close, I want to address something that comes up in our comments regularly, and it comes from a place of understandable frustration. People ask, will Congress ever fix the backlog? Will the per-country caps ever change? These are legitimate questions, and I hear the emotion behind them. The honest answer is that legislative reform to the employment-based immigration system, particularly around the per-country limits, has been discussed in Congress for years. Various bills have been introduced, debated, and in some cases passed one chamber only to stall in the other. As of the date of this video, the fundamental statutory architecture that governs per-country caps remains in place. Any change would require an act of Congress and presidential signature. The immigration landscape continues to evolve, and our channel will keep you updated on any developments. What we can say with confidence is that within the current system, the best thing you can do is know your position, stay organized, file when you are eligible, and work with qualified professionals who understand the landscape. I also want to say something to those of you who have been waiting a very long time, some of you for a decade or more. Your patience and your perseverance deserve acknowledgement. This system is challenging, and the uncertainty that comes with it affects entire families and careers. This channel exists because we believe that clear, accurate, and accessible information is one of the most important things we can offer people navigating this process. You deserve to understand the system, not just be subject to it. As always, remember that everything we share on this channel is informational in nature and is not legal advice. Immigration law is complex, circumstances vary widely, and the policies and dates we discuss can change from month to month. For guidance specific to your case, please consult with a qualified immigration attorney or accredited representative. You can verify all information we reference today at the official U.S. Department of State Visa Bulletin page, travel.state.gov, and at uscis.gov, where the monthly adjustment of status filing charts are posted. This content reflects information available as of February 13, 2026. Policy changes can and do occur, and we encourage you to verify with official sources regularly. If this video gave you clarity or helped you understand where you stand, please give us a thumbs up. It genuinely helps other people find this content when they need it most. Share this with someone who is on this journey with you, because knowledge shared is power shared. And if you are not already subscribed to Immigration News Today, please do that right now and hit the bell so you are notified every time we post. We publish daily updates on immigration rules, green card developments, government policy changes, and everything that affects immigrants and their families in the United States. Check the description below for links to official resources, including the USCIS Visa Availability page and the Department of State Visa Bulletin Archive. This is Immigration News Today. We will see you in the next video. Stay informed, stay prepared, and keep moving forward.